Before we start, they have your names, but each of you, basic affiliation and why the hell you're here. Joe?
Well, I'm Joe Watley. I grew up in Monroeville, Alabama, which was the home of Harper Lee and the site of To Kill a Mockingbird, and we all wanted to grow up either to work in the paper mill or be Atticus Finch. And I think I'm here because I handled some voting rights cases and employment discrimination cases, both classes, in front of Judge Thompson when Tom Sharp was clerking for Judge Thompson. And after it became impossible to win any of those cases in the 11th Circuit, I branched out to other kinds of class actions, and that's what I've been doing.
And you're now based in?
Based here.
You're based here. You're a New Yorker.
I suppose
Come on,
so.
admit it. You're a New Yorker. Okay.
I'm happy to be here.
As a New Yorker, you don't sound like a New Yorker. But I won't hold that against you. My name is Adam Klein. I'm a plaintiff side employment lawyer, and my area of concentration is class actions of statutory discrimination and wage and hour claims. I guess the question here is, our cases were hard enough before Iqbal, and now they seem almost impossible, or at least perhaps that's what the first panel suggests. And I'm hopeful that that's not an accurate perception, but I suspect that at least the management lawyers I encounter in support of the motions to dismiss, which there will be many, will make that argument. So at a minimum, I'll be educated about what I should say.
John?
I'm John Beisner. I'm with Skadden Arps, based in Washington. Spend most of my time defending class actions, and I think I'm here today because Joe and I were going to be emailing each other, and we thought the reception would be better if we're in the same room.
So we have goalposts between the two of you.
Yes.
Yes. Elizabeth?
Yes, I'm Elizabeth Cabraser from Leaf, Cabraser, Hyman, and Bernstein, primarily from San Francisco, occasionally from New York. I was educated at the University of California, Berkeley, which taught me that the people united will never be defeated. Went to law school there, too, and found out that litigation is the private enforcement of the social contract. I think I may have confused the class struggle with class actions, so I represent plaintiffs in class actions and other aggregate litigation.
Thank you. Jay?
I am Jay Eisenhofer from Grant & Eisenhofer. I am a plaintiff's securities litigator, and I think that I am here because ACS wanted to have a representative of every single plaintiff's firm here.
My name is Robert Jufra. I guess you might describe me as a civil rights lawyer of sorts. I represent such unpopular folks as bankers, foreigners, and other folks who do well before juries. And I have a lot of cases with my good friend, Jay. I still take commercial. He's got the jet.
Miriam?
Hi, I'm Miriam Gillis. I'm a professor at Cardozo Law School. And I think I'm here because I write a bit about class actions. One of my drafts is in the CLE materials. Any comments are welcome. So I think I'm here because Jeff Miller, John Coffey weren't available. So this
Not
is why I'm here.
so. Don't get that way, Miriam. We're delighted to have you
Thank you.
here.
I'm Ted Frank. I run the Center for Class Action Fairness, which represents consumers in class action litigation when the class action has settled, but the consumers somehow seem to have been left out of the settlement.
Ooh. That sounds bitter. Are you bitter?
I cling to my guns and my religion, but other than that, I'm okay.
Sal?
Hi, Sal Graziano from Bernstein Litowitz. We represent institutional investors in securities class actions. And I think if I had to just give probably the strongest reason why I'm here, it's probably the Supreme Court's decision in the Stonebridge case. I can take a lot, but that one is particularly difficult to understand. And I think we'll talk about that somewhat today.
We had a bit about that in the first panel. Not favorably, not favorably.
Well, okay, let me start then, because I'm not sure if this was discussed by the first panel, because unfortunately I had a conflicting meeting. But I went to that argument, and in the very beginning of his argument, the lawyer representing the plaintiff was interrupted by Justice Roberts, who said with a smile, "We stopped making law here a long time ago." And then the court went on to create a brand new reliance requirement in that case that hadn't existed and was never litigated in the case below. It was really shocking.
Liz, why are you looking at him that way?
I
We're
was
going to do this
fascinated-
on a psychoanalytic basis.
Okay. I was fascinated by the statement, and I've been puzzled by the same thing for a long time, that we have a court that, with a frequent majority that claims not to be in the business of judicial activism or making new law, but we have new law after new law after new law cooked up in the Supreme Court, including today's decision overturning campaign finance restrictions in a breathtaking way. So it's a radical court. I'm not necessarily opposed to a radical court. Perhaps a slightly different configuration would
In other
be
words, the
preferable.
arrow is going the wrong way. Now, John, you're smiling there. You look like the Cheshire Cat. You're happy, aren't you? Class actions are going to die, right?
He doesn't want that to happen.
No, I think that judging by the number of filings that are being made and so on, I think class actions are far from dead. And I think if you look at, I didn't update it for the last several months, but did look a few months ago when people sort of like Iqbal were saying that hydrogen peroxide had brought an end to classes that would be certified, took a look at what the appellate courts had done since hydrogen peroxide came down. Now, bear in mind, that's a very different animal since that's a Third Circuit decision, not a Supreme Court decision. But in the 9 months of 2008, after it came down, there were 37 appellate court decisions reviewing class certification rulings, and 13 of them either upheld a grant of certification or reversed a denial of certification. Now, you know, there may be some who say, well, everything ought to be certified. Okay, fine. But I mean, I think it indicates that the appellate courts are seeing cases that are certifiable as classes. There may be some who would argue there should be more, but I don't think the device is dead by any stretch of the imagination.
But would you acknowledge or not acknowledge that it's a bit of a wounded bird situation?
I don't
it's
think
not just hydrogen peroxide. It's Canadian cars, it's IPO, it's Oscar, a whole slew of cases.
I think that what's happening in these cases really is not so much a change in standards, but a recognition that before a class is certified, there really does need to be a searching, what I would refer to as sort of due process or fairness inquiry to make sure, looking at the case from both sides, both from the plaintiff's perspective, the plaintiff class perspective, and the defendant's perspective, whether it's fair to put the questions presented before a jury in one bite, whether the jury is going to be conflicted, legitimately conflicted, saying, well, some, it's yes for some and no for others, and whether that's fair. And I think a lot of the decisions are simply saying there needs to be a more searching inquiry in some of these cases, and I think that a lot of the firms I confront who are very good at doing this have been doing that for a long time and have built the right cases, and the cases that aren't succeeding are those where the blocks haven't been put together properly.
Joe is scowling.
Well, I'm not scowling. I keep thinking that what we're hearing from is the father or the godfather of the Class Action Fairness Act. You know, we thought there were a lot of places where it was fair to have class certification proceedings, and now we're pretty much limited to the federal courts with rare exceptions. And not that they can't be fair too, but you have clearly seen, Arthur, the kinds of cases you're talking about. And part of what is termed by some as fairness is on the other side termed as class certification that comes after much more extensive discovery, after a much more developed record, after much more money invested and time invested by the courts and the parties in experts. And you're so far down the line that the only lawyers that can afford to bring class actions are lawyers that have very significant resources. And the only clients that will ever have the possibility of successful class actions are those that can come up with people that have significant resources, and there's an attrition process for that. And so it is clearly by saying fairness, and with all due respect, because I have tremendous respect for John, but by saying fairness, what we have seen is let's add tremendously to the cost in the process, so even those cases you can win, there's a huge roadblock.
So in the environment of today's seminar, that's the access point.
Exactly, that's the access point.
The cost is prohibitive. But because you can't really fight the American apple pie baseball motherhood notion of searching inquiry.
Well, cost is not prohibitive in every case, but it is prohibitive in many cases. And it means that many cases that need to be brought, many issues that need to be addressed, can't be addressed because you can't bear the cost of bringing those proceedings to meet the standards that the excellent lawyers like John have developed.
Now, Miriam, you have a social philosophy here.
I do. I guess, so if we set aside the cases, I totally agree that there are going to be a set of cases that, like the antitrust cases and the securities cases where there's just, searching inquiry is the standard that all the lawyers are playing by. And there's going to be a tremendous amount of time and energy front-loaded into those cases before you bring them. But when we think about Rule 23 and what it was intended for, I think we could all agree that it was originally intended, at least in large part, for small claims consumer class actions, right? For the kinds of consumer cases where a corporate misfeasance injures lots of people in very small ways. And those are the sorts of cases that oughtn't be very expensive to bring, right? We shouldn't have to front load a tremendous amount of time or money at the beginning point of those cases, because often wrongdoing is pretty clear. But those cases are largely uncertifiable today because of this ascertainability requirement that I wrote about in this draft.
What do you mean by ascertainability? For those
so ascertainability has been, I don't know what, well, I don't know what it really means. It's sort of, it's been written into Rule 23 by a number of decisions. Basically, the inquiry there is that, in order to certify a class, the judge says we have to know who's in the class. It has to be something we can actually sort of understand. And if you think about your typical consumer class action, say, I bought a pineapple, back in 2008, and it turns out that Del Monte was overcharging for its pineapples because it had illegally obtained a patent. Right, so it was charging, because pineapples are really darn expensive, it turns out, and it's all because of fresh Del Monte. And so, I'm part of this putative class that wants to get some relief for that, or I'm the lawyer bringing this class action based on that illegal conduct. You can't certify that class, says a judge, because we don't know how many people purchased that pineapple. We don't know who purchased it. Who purchased those pineapples back in 2008. And so there's no way for us to ensure that if we do certify this class and we eventually get the settlement, that we'll be able to get the overcharge into the hands of the people who actually overpaid for the pineapple. So because we don't know what's going to happen later at the damages stage, we can't certify the class now. So I think that's hugely problematic, and whether you think about it as ascertainability or manageability or a question of due process for notice, it strikes me that this is sort of being written into Rule 23 at the certification stage. But I think it's part of a sort of broader, effort to slowly kill off the class action device. Because if
Who's the killer? Who's the killer? Other than John, who's the killer?
Other than John, that's tough. I think that the panel, the last panel ended with somebody asking about sort of public opinion. I think public opinion has a lot to do with it, right? This conception, and Ted could probably talk about this a bit. This conception, this idea we have that that these are all lawyer-driven suits and therefore they are bad. Right? I mean, so much of positive change in this country is lawyer-driven, right? I mean, we're sitting here at NYU Law School. People come to school because they think that that they can make change, and they can make change in positive ways. But somehow, with class actions, the idea that it's lawyer-driven makes it inherently suspect. The idea that lawyers will actually make money because they should work for free after all, that's inherently suspect. And I think a lot of it is public perception. And public perception then allows judges to be skeptical when they are faced with a certification decision. It allows judges to be skeptical when they get the attorney's fees application. It allows for all sorts of skepticism about the device and about why it's being used. So I don't think there's one killer. I think it's 1,000 points of light.
Bob, you have views on lawyer-driven, I know that.
I'm sort of surprised because from what I can tell, class actions are alive and well and living in federal courthouses all around the country. I mean, I think we're hearing a lot of overstatement. Let's take the securities area where I do most of my work. More than half of all securities cases that are brought end up in a settlement. So if you're a plaintiff's lawyer, you bring a case, you've got more than a 50% chance of a recovery. Plaintiff's lawyers have recovered billions of dollars in damages in the last 10 years in securities cases. These cases are very much alive and well. Now, on the question of why they're brought, clearly they are, at least in the business type class actions, are motivated by plaintiff's lawyers. Some plaintiff's lawyers like Jay, great people, trying to do their job. There are others who, one could question their motives and why they were doing things, particularly back before the Private Securities Litigation Reform Act. You had plaintiffs' lawyers who were paying off plaintiffs to serve in cases, some now in jail, we know who they are, and they were bringing strike suits, holding up companies. And by the way, companies are owned by shareholders. Employees work for them. There are customers who work for them. The costs of class actions get passed on to the broader society. It's not as if you're just making, some executive pay. Everybody pays from the cost of our litigation system, and the question really is the cost worth the benefit? And oftentimes in class actions, the lawyers make money on both sides, plaintiffs and defendants, and very little money goes to the so-called injured party, and companies just pay money to deal with a system that's very inefficient.
Yeah, Arthur.
I'd like to just make a comment. First of all, in response to John's claim that nothing has really changed, just let me give you a statistic. The reversal rate of appeals from denial of class certs from 2005 to the present is 17%, but the reversal rate of appeals from grants of class cert in that same time period is 69%.
Which shows that district courts are making too many errors on the plaintiff's side.
No, but that's not what happens.
Okay,
What happens is an appeal.
Maybe it is, but let's not
There are
say
discretionary appeals, though.
let's not say that it doesn't show something has changed. Also, let me read to you a comment by John Coffey, who does a survey of class actions every year. He's got no ideological stake for one way or the other. This is a completely nonpartisan survey. His conclusion as of this year is, as of this juncture, the long-term future of the class action is in doubt, and only some basic compromises, such as the acceptance of partial certification, seem likely to maintain it as a broad form of litigation practice. So I think that we should have an honest discussion of the topic and not claim that nothing has changed, or just because a lot of class actions get filed, that means that there's not a serious threat to the existence of class actions. The fact that cases get filed doesn't mean a thing. How many cases get certified? You cannot get a consumer case certified except in extraordinary circumstances. And now the attack has moved to securities class actions. It is still, securities class actions are still certifiable, but they are nowhere near as easily certifiable as they were only a few years ago.
Yeah, and not only do I agree with Jay, but let's go back to what Bob said, because it's even more remarkable when you understand these difficulties that billions have been recovered. And you have to wonder, would Bob ever let any of his clients pay billions to settle these cases if there were no merit to the cases? So we have to look at both sides of this, and if not for Enron, WorldCom, and many other amazing corporate frauds, these billions would not have been paid, they would not have been recovered, and they certainly were lost by the shareholders, the public pension funds that Jay and I represent. It is a different world today. The PSLRA is in control, and the persons bringing these cases are major United States and foreign institutional investors that invest billions of dollars.
Well, what about the allegation, which is quite frequently repeated, that the institution of the action in and of itself creates an environment of a compelled or, as they say, extortionate settlement.
I think there's certainly something to that. You look at the Enron cases, many of which eventually got struck down for the parties that did bother to litigate, but the ones who didn't, facing $50 billion of liability, and they settled for 4 cents on the dollar. And $2 billion is certainly a lot of money, but I've yet to meet the most fervent advocate of the American justice system who says that the system gets it right 96% of the time. And so you're essentially paying the protection money when you're paying a $2 billion settlement over $50 billion of allegations. And you know, these are smart plaintiffs' lawyers. They don't settle cases for less than that they're worth, and these were essentially settled for nuisance value.
Ted, do you think that in slip and fall cases, they get it right 96% of the time? Or that there aren't settlements that are engineered or entered into simply because it's cheaper for the company than to litigate? I mean, what's different about the class action than the environment in the rest of the litigation universe?
I don't think I've ever said that the environment in the rest of the litigation universe is especially good.
So nobody gets it right.
Well, I didn't
It's
say
an
nobody gets
approximate
it right.
system.
I just said that nobody says that they get it right 96% of the time. And when
Well,
you
I
have
thought
a
that was
$50
the
billion
standard
suit,
you were setting up. John?
I was just going to say, I don't know about the percentages of right and wrong. I'm not sure I'm qualified to get into that. But I do think that the filing of a class action does create a different environment. I think at most companies, the class action comes in, that goes in a different box than the slip and fall case goes in. It gets a lot more attention. And, you know, I think one of the things that is forgotten, because I think Joe is correct that decisions like hydrogen peroxide that are saying you need to have more of a record and so on are resulting in more discovery, but you know that's a cost for the companies as well in those cases. And so I think the cost of discovery in those cases, which is often more than in other cases, but just the fact that, you know, even though it may be a consumer claim for $500, if it's multiplied by 100 million purchasers of the product, it's going to create a significant risk. And I think it does create an environment that creates pressure for settlement.
See, Elizabeth, you're a pressure point. You're an interorum device.
Well, thank you, but I only wish. I mean, I think one point that gets lost in this discussion is that in one sense, a corporation, for example, that manufactures a product or provides a service is a pre-certified class. It's an aggregation of capital. It's a limited liability corporation. It's a powerful entity. And it is dealing with consumers or investors as a mass, as a group. And so to presume and consign plaintiffs to individualized status unless and until they can prove otherwise creates a systemic imbalance, which limits the good that class actions can do, which adds to the cost of class actions, and which doesn't result in a system that has balanced scales at the outset. The burden of proof on the merits should be just that, the burden of proof on the merits. Instead, there are barriers to entry, there are barriers to access, there are cost barriers. This notion that corporations operate in the 21st century collectively in the aggregate. Supreme Court upheld that again today. You can make all the campaign contributions you want as a corporation or as a union. Collectives are good, but not in class actions. And the problem is that people in society are dealt with en masse today. We buy standardized goods. We're subject to mass advertising. And when we get injured or damaged or harmed, we tend to do it on a mass basis. But yet we're consigned to the 18th century version of due process where everybody's an individual, while the corporate defendants are operating in the 21st century. And I think that's a tremendous imbalance That's a very heavy burden for class actions. Class actions are criticized when they can't overcome that imbalance, and they can't do perfect good, and they're compromised. But yet, the cure is, it seems to be to have even fewer of them.
Adam?
I barely recognize the discussion in terms of Rule 23 litigation from where I sit. As an employment discrimination lawyer, we look at cases from a completely different perspective. We often see societal ills, like the fact that 35% of African American males are unemployed in this country. The women earn 70 cents on their male counterpart dollar. And ask the question, why is that happening? And then look to particular outliers within industries and challenge those practices. This isn't about extortion. It's not about how much money we can generate in fees or how much of the class fund we can create through a settlement. That's not the objective. The objective is to try to remedy societal ills. There's a great example of that right here in the Southern District of New York, a case called Vulcan Society versus New York City. The fire department of the city of New York was found to have been intentionally discriminated against black applicants, and they are now in the process of a stage 2 process to create a quota or super priority system for disadvantaged blacks who have not had the benefit of a job in the fire department, which parenthetically is an excellent job. And there are lots of examples like that. And so from my vantage point, the discussion, the spillover effect, if you like, of a discussion of greedy lawyers and extortionate, extreme back-to-ranch exposure, that those concepts are foreign to me. And it's unfortunate because I think a lot of those precepts, a lot of those views are spilling over into the jurisprudence, and hydrogen peroxide at IPO and cases like that are the unfortunate consequence, and yet, and Iqbal as well, and to some extent, and yet, the defendants are quite happy to cite all that in response to an employment discrimination lawsuit.
Let me just clarify a point, because I'm not a subscriber to the extortion notion. I'm not sure that's a fair statement. So if you heard me saying it, it was not intended.
Wasn't your ad.
Not intended on my part. But I think the point is that the courts need to recognize that this is an extremely powerful device. You have an attorney and one person, often, going into court saying, we're here and we represent thousands of people. Did we ask them if we want to be represented? No. Did they tell us they want to bring this lawsuit? No. Now, I think, in the consumer area, it may be, yeah, the consumers are behind you 100%. That may be the case, but the court's got to be a little bit skeptical of that case coming into door, because there are some conflicts of interest there. But the lawyer is, got control of the lawsuit often, or just with the named plaintiff, and they may or may not be acting in the best interests of the class and negotiating a settlement or making decisions about what to give priorities and so on to. And it's just a different kind of lawsuit than you have when you've got one plaintiff and one lawyer who decides that they want to bring an action. And so in that sense, the need for this greater scrutiny, I think, has a lot to do with the need to make sure that the rights of the class are protected as well.
I think it's a false choice when applied to the employment statutory discrimination realm, because as it happens in those cases, oftentimes the individual damages are modest. If you have an hourly employee working at Walmart, for example, their individual claim may not be worth more than $10,000 or $15,000. No one in their right mind would think to bring, or could afford, most importantly, to prosecute a case against a company like Walmart. And yet, there are very important issues at hand. There are practices that are disadvantaging entire populations within our U.S. workforce. And those are important concerns. And so it is true, plaintiffs' lawyers have a lot of power to fashion these lawsuits to try to affect change within companies. But I think ultimately that's a societal benefit, and it sort of doesn't speak to this question of imposing costs on defendants and sort of shifting back to consumers. That's a foreign concept, I think, to the issues that we deal with.
With all respect to John, I always snicker a little bit when I hear defense lawyers talk about protecting class members, and in part because, because I don't believe it. And I don't believe it, not because you're representing the defendant, the corporate entity that's engaged in the alleged misfeasance, but because I don't think that's really why you do anything you do in defending this corporate defendant. So I think that this idea about protecting the class member, I think we have to leave that to the fiduciary judge. I really do, because I don't think that, if we don't trust the plaintiff's lawyers because we think that they have a conflict of interest, which at times they may, and we don't trust the defense lawyers because they don't really have a dog in that hunt. We have to leave it to the judges. And the first panel talked a bit about trusting our district court judges. There's certainly no reason not to trust them to try to take care of the class where we think there's problems with the class. But I think more generally, when we think about the differences between, just going back to Adam's point, when we think about the differences between different kinds of class actions. In the earlier panel, I sort of sat there, thought we should really be separating out the constitutional cases from the antitrust and securities class action cases, because Iqbal may affect both of those sorts of cases similarly, but the real world effects will be different given the kinds of litigation that will go on in national security versus securities. Here, I guess I'm sort of feeling with Adam that an effort to distinguish civil rights class actions or employment class actions from other types of class actions, I think it's admirable, but Rule 23 is Rule 23 across the board, right? And I think it's more than just spillover effects. I think that you sort of have to realize that whatever perceptions are out there about class actions are going to affect all class actions, right? No matter what the substantive allegations are.
And the Fifth Circuit effectively killed Rule 23 Title VII claims in Allison v. Seco Petroleum. In that case, the court basically said, damned if you do, damned if you don't. If you try to bring a class action to enforce statutory rights, and your individual class members have a right to individualized damages, you cannot certify that class. And for a long time, and it continues. There are parts of this country that I wouldn't consider bringing a case.
Well, I think we're sort of missing the big picture, because we're assuming that class actions are just this wonderful device in all circumstances to create justice. Now, right now in the United States of America, we have 10% plus unemployment. Our growth rate, it's not that great right now. We have a great legal system, the best legal system in the world. In Europe, no class actions. Asia, no class actions. People in Asia and business people in Europe, they don't want to invest in the United States because they think we have an out-of-control legal system. And the consequences for that out-of-control legal system are felt because people don't invest in our businesses. The costs of the litigation system get passed on not just to the shareholders, but the shareholders are, as Jay's clients, public pension funds, get passed on to the employees. People don't, you can't pay higher wages, you can't hire people. And there's just an assumption here that class actions are powerful and good in all circumstances, and we should just let as many of them as possible go forward. Be good for me personally. I doubt it's very good for the society. And the thing that gets lost in this is that allowing one lawyer with a law degree to come in and bring a lawsuit on behalf of a whole bunch of people who are not before his clients, he's unaccountable to anyone other than the person who he's signed up to be his named plaintiff. And we know from recent history that there have been people who've been paid off who are nothing more than puppet plaintiffs. You're essentially allowing lawyers to go around and I'll use the word extort. In some cases it can be, because in the securities class action area, before the PSLRA, many companies made a cost-benefit decision, which was it was easier and cheaper to pay off Mel Weiss than have to go and deal with the discovery and everything else that would be associated with it. He got fees and the cases were resolved, but it did not benefit the broader society.
Yes, I beg to differ, but in merely...
I'm shocked.
In merely two respects. It's interesting that Europe, Latin America, Asia, most countries on those continents are struggling to enact and to implement and enforce various forms of class actions. Class actions are on the rise internationally, not on the wane. They don't take the form that class actions take in this country because those legal systems are different. But there's lots of experimentation internationally because from the consumer perspective, those class actions are needed, and from the business perspective too. I would also say this. I think one reason we have 10% plus unemployment and a melted down economy is that class actions, investment litigation, antitrust litigation, consumer litigation were not allowed to be robust enough. And there wasn't enough enforcement of the laws we have, and business and commerce ran on the honor system for 10 years. And everyone that benefited and profited from those systems didn't need to be corrupt for the meltdown to happen, and most were not corrupt.
Can I just respond to one thing? That's just not true. The recession is a worldwide recession. Banks all over the world, the stock prices have gone down. Real estate markets fell all around the world, in Europe, the United States. So it's not as if it's just a U.S. problem. It's a global problem.
It exported from the U.S.
But,
The other problem with what Bob said, just so it's clear, is that his foreign clients actually pay a premium to be listed and traded in the United States. So it really is hard to follow his logic.
They're actually delisting, and it's a big problem for New York because Wall Street has been the economic engine that's kept the city going. It's paid all the taxes that are paying for all the services, and we'll end up being, basically a tourist town if we don't watch it.
I think the last time we checked was in 2009, and it still proved the case that we had more new issues in this country than other countries from foreigners. It actually is not held up by the facts that they're examined. But going back to something else he said, I thought we were talking about 10% unemployment because of class actions in the United States. I thought that was your argument, and then you just talked about a worldwide recession.
No,
I'm having trouble following you, basically.
My issue is that our legal system is we want to resolve every issue through the legal system, and there's a cost to the legal system. You make money, I make money. How much money actually goes to the damaged people in many of these situations? Oftentimes, pennies on the dollar, if that at all, where people get coupon settlements, which was a big problem with class actions in many cases. And even in securities class actions, because I get the notices in the mail, you own stock in something, I don't fill out the forms oftentimes because maybe I didn't have that much stock in the company. And so it's a big expense. Now, if you want to use the government, to lock people up who engage in real fraud or real crimes, I'm all for that. I don't have a problem with that. But often what happens is we assume that the class action in and of itself is a good. In some circumstances, it makes sense. In others, it doesn't and can be abused. And the point is to have a balanced system.
In terms of balance and scrutiny, I just want to make a point on the securities side of these class actions, which is there is tremendous scrutiny and there is terrific change. The public pension funds have actually brought down the lawyers' fees dramatically. They are no longer the 30%, 33% that they were 10 years ago. They're as low as in the single percentages. There are significant
That was the
amounts,
Republicans that put that in.
There are significant amounts of but we have to talk about the system today and not criticize something that existed 10 years ago. There are tremendous
well, you're trying to bring back the system that was 10 years ago, so it's worth the comparison.
Well, I don't know who is. That's
well,
what I'm trying to understand.
HR 4115, for example, wants to undo what the PSLRA's pleading standards are.
I actually disagree with that, but let me just finish the point of how much scrutiny there are in these cases. Today, if the institutions are not happy with the recoveries in the class actions, they opt out. They are opting out in growing numbers. Their institutions themselves, public pension funds, are objecting to fees and getting fees lowered in these cases. So scrutiny is not an issue for us. It's working well.
I agree 100%. That was something that was put in the Private Securities Litigation Reform Act, and the whole point was to deal with the abuses. And oftentimes what people will say about the PSLRA is it somehow stopped securities class actions. In fact, what happened was the PSLRA cleaned up the abuses that were there. The figurehead plaintiffs, the race to the courthouse, it's a much better system than it was. And all that I think needs to happen is balance.
I wanted to come back to a second to a point Elizabeth made, because I think she's right that oh, we've agreed before. That she is right that the subject of adopting forms of collective litigation are a hot topic in a lot of places outside the U.S., certainly a hot topic in Europe at the moment and also in South America. And I do think, as she pointed out, it is interesting what other countries are doing with this and their reaction to the U.S. experience, which brings me back to the exchange I had earlier with Miriam on this. First of all, I didn't purport to say I represent the interests of plaintiffs in those cases. I wouldn't purport to do that. But as a student of the device and looking at what the roles of counsel need to be in that, I do have a concern that the way our setup works, there isn't always an advocate for the class. I think you're right. There are hundreds of cases where the counsel for the class is doing everything they're supposed to do. But I've been in cases where the judgments that have been made, I have to say from my standpoint, were to benefit the counsel who were involved in derogation of the interests of the class. And I think it's interesting that that is one of the things that the foreign countries, the countries outside the U.S., are reacting to, I think, the most in structuring their device by having systems established as to who may bring these actions. Not just any lawyer may do it. There needs to be an organization that's got some governance and management structure that brings these. So it's not a single attorney making judgments. I think most of the countries in Europe that have adopted it have said we're going to have an opt-in system, so that the plaintiffs, the class members, have to make a decision affirmatively to participate in litigation rather than just being assumed to be part of it otherwise. And so I think that the only point I was trying to make is I think that one of the reactions of the courts here is a concern about whether there have been abuses because there isn't an advocate there for the class. There are a lot of cases it's not needed. Counsel's doing everything they should. But I have to say to you, there are a number of cases where I'm not sure the best interests of the class, just sitting off in my corner being the defendant, that the best interests of the class are
But
being
John,
represented.
you also know that one of the liveliest growth businesses in this country is objecting to the settlement.
Oh, yeah.
So, although they often are self-interested in their intercessions.
No, and I'm not saying that those persons are necessarily representing the interests of the class in all cases either. But the point is that with the fees that are at issue in these cases, and the fact that although I concede there have been some exceptions, we really haven't gotten around to the discount of fees that should be there for the efficiencies that are being asserted up front. There's a basis for, I think, a fair amount of abuse and whether the class, in a lot of cases, is being adequately and properly represented.
Yes, Adam, what do you say to that?
Again, this is a tale of two cities. On the one hand, you have what are essentially money damage cases, antitrust, consumer securities, and on the other hand, in my sleepy little part of the world, perhaps, we really don't think in those terms. And an advocate for the absent class just doesn't compute. I don't know what they would do. I will tell you that as part of a settlement process, we may spend more than a year working with experts, including IO psychologists and social psychologists and statisticians, working through the very problems that our clients are experiencing with a settlement agreement that has a term for years with substantial injunctive relief. That's the nature of the litigation. That's the nature of the reliefs obtained. The money is there, but that isn't the primary objective. You may be cynical and think that, well, that can't be true. That it sounds implausible. I will tell you that is exactly the case. We've represented people like African deliverymen who weren't paid more than $1 an hour here in New York, brought in conjunction with nonprofits. There's a whole realm of cases that simply do not fit the model that's being described, and the concern is that some of the overreach that's being identified will spill over and adversely affect these kinds of cases.
Let me just give a concrete example on this, because I have no question about the zealous and responsible representation that you're giving in the employment context. But I have been in cases, and again, this isn't an argument against the device. Don't get me wrong. It's an argument with respect to the need for supervision by the courts of this. I mean, I've been in cases where people argue for employment classes that are entirely too broad. there may be a viable class there, but because of the financial interests of counsel, they're just saying, well, let's do the whole company, or let's do, and there's not an effort to subclass and so on. And so I guess really what I'm saying is that there's, this is where I do have some concerns in those circumstances, and classes get denied or they get certified, and then you get summary judgment against the entire class. There have been instances where I think class members have been injured.
Well, I think it's almost impossible to certify a class that is so-called across the board claims. Falcone v. General Telephone Electric, Supreme Court killed that years ago, and I'll tell you, the practice has become increasingly more difficult. Basically, the attack is more narrowly focused. The claims are tailored specifically to the claims that can be certified. That's the alpha and omega of the analysis. It isn't a broad-scale attack. It isn't multiple job titles. What it is a particular policy practice affecting a particular job category based on race or gender. And that's the vast majority of employment cases. That's unfortunate because there are broader issues at play, but they're uncertifiable, even here in the New York courts, or as I affectionately call the Northern District of California, the Eugene V. Debs Memorial Courthouse. Even there, it's impossible to certify a broad class.
Well, and you got to remember one thing, too, that's kind of getting missed in all this discussion. It is only in the class action context where the court is there to provide some protection. There are clearly abuses in individual cases. You got people involved in this process, so there are always going to be abuses in any system you come up with. But in the individual case, there is no court supervising the resolution of a case and what might happen between a lawyer and a client. In the class action context, there are many procedural devices and a court there to supervise and assess whether there's a fair and reasonable settlement. There are protections in the class action area. Do you sometimes see those protections avoided or see abuses? Of course you do. But there are protections there that protect people, and you have very, very many excellent outcomes. I mean, we have in settlements for doctors against health insurance companies where we achieve similar kind of relief. The polybutylene cases that Elizabeth and we were involved in where people essentially got full refunds for replumbing their houses. Elizabeth's siding cases where they got close to the same relief. I mean, there are cases after cases where you see very, very positive results. I'm not sure you could get those results today under the class action standards.
What's the biggest obstacle you face in getting the case certified? What's sort of the fulcrum?
Well, there are many, but I think that the issues of being able to show predominance and superiority in the normal 23B3 class action, and you're left with, and this was a lot of the discussion earlier today in the earlier panel. There is so much discretion in terms of class actions. I mean, the courts always say the issue of whether to certify is discretionary, and I suspect it has to be. But judges aren't fungible. I mean, they can be very different. You can have a class that will be certified in front of one judge that would never be certified in front of another judge. You can have a class that would be affirmed in front of one panel in a circuit that would never be certified or affirmed in front of another panel in a circuit.
And there are blackout circuits where it's worth your life to go to.
Well, that's true. And having appeared many times in front of Judge Joe Flatt, until we appeared with doctors who were fellow members of the country club, I don't think he ever saw a class action he liked. But Rule 23 was established for fellow members of the country club. We all know that. But I mean, it is the burden of being able to show, and it varies from case to case. I mean, you would think a price-fixing case is a simple case to certify. Maybe you win or lose on the merits, but if there's price-fixing, it ought to be a simple issue to certify. Well, after hydrogen peroxide, there are all sorts of evidentiary questions and expert questions and perhaps even Daubert questions to get over before you get to certification.
So it's front-loaded, as was said earlier.
It's very much front-loaded.
Now, Elizabeth, this predominance issue, when you're under a federal statute, it's a bit easier than when you're in a common law consumer or fraud type case. What do you face?
Well, first of all, we face the fact that predominance is not defined in Rule 23. It's one of those things that I think I know when I see it. It turns out I have been wrong in so many ways. And it is basically calling for a subjective judgment call by the court. And it turns out how you look at the universe. Physicists look at the universe, and there's predominance all over the place. Most of the universe is neutrinos. You look at predominance in another way from an individualized perspective, and you never see predominance of common issues because everyone is absolutely unique. If there were a utilitarian interpretation of predominance, you would do the greatest good for the greatest number. You would see predominance of common issues where it was sensible, cost-effective, fair, and economic to do so. If more judges interpreted Rule 23b3 predominance through the prism of Rule 1, I think we would have more class actions. But instead, predominance has become more and more and more difficult to achieve. I think defendants know predominance much better than plaintiffs do. If your ad campaign is effective in selling your product, you've hit predominance. You've hit those common issues that resonate with the buying public. So predominance for defendants when they're selling products and services is not the same as predominance for the plaintiffs when they have to prove a class action. And I do think that courts had an easier job acting as chancellors in equity, and class actions were originally in equity, to find predominance where it made sense and was fair to do so before they were facing Rule 23F appellate exposure every single time, which I think is the biggest burden in class actions today. I'm a great fan of the federal appellate courts, but I think it's not necessarily optimal to have appellate courts making case management decisions in class actions where so much time and expense goes into the class certification process.
What are we going to do, if anything, in the context of diversity-based class actions, where the inevitable problem is the multi-state law issue, which kills predominance? So you have a business practice that seems to be uniform, impacting people in a uniform way, but it's arising under the quote, 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 common law or statutory law of 40 different states.
Well, one could have state-by-state class actions, and that's what's happening right now. We could have a national choice of law doctrine rendered either through legislation or jurisprudentially. We don't have that. The Class Action Fairness Act doesn't feature that, primarily because of the no amendments rule. So despite a choice of law amendment, we don't have that. Phillips Petroleum versus Schutz does not get interpreted as a choice of law doctrine, although it is, at least in the constitutional sense of due process. I think we're asking federal courts to do something nearly impossible when we transport all state law-based class actions to the federal courts, because they involve interstate commerce, and they do, and nationwide problems, and they do, and then discourage them from using available choice of law techniques or from devising choice of law techniques that are going to enable them to certify and manage and adjudicate class actions.
Now, John, you were, and I say this with great admiration, although philosophical disagreement, you are the architect of CAFA. And as you well know, some of us tried to get a choice of law provision into CAFA to avoid this problem.
I don't understand what the problem is, and let me start there. I mean, if you have a group of people in California who say that the California unfair competition law has been violated, maybe you have a class. What you're saying is, well, if I'm a lawyer, though, and I want to do a nationwide class, shouldn't we have some provision where we sort of make up a law that will apply to this nationwide class, as opposed to having the case proceed under the law that was supposedly violated? I mean, I think that, I guess the first thing I note, I find it interesting, I think one of the effects of CAFA has been, in the class action context, for there to be a rediscovery of federal law. For a long time, everyone said in their class action complaint, this doesn't implicate federal law. I specifically say federal law is not being invoked because they wanted to avoid being in federal court. What's happened since CAFA is now people have sort of rediscovered, well, there are lots of federal laws that are actually more beneficial to the class that are now being sued under because you're going to be in federal court anyway. And so I think that this choice of law problem is probably somewhat overstated. I'm not saying it doesn't exist, Elizabeth. I think you're exactly right that there are cases where this comes up. But a lot of people are just invoking federal law, and you don't have that issue in those cases. But where it does come up, I think, to say, well, there needs to be a mechanism where we will make up a law. We'll have a composite law of all the states that will apply to these claims, or we'll just pick one out that will apply to the nation, I think is very problematic. I mean, what's the law? I mean, why is it that a class action, because you want to bring it on a nationwide basis, you just make up a law or choose one state's law that applies to everything?
John, you were so successful in selling Congress on the notion that multi-state class actions inherently were in interstate commerce and should be federalized. So what's wrong with a federal choice of law provision?
If there is a federal law that you claim has been violated, which is what I'm saying I think has been rediscovered by many practitioners bringing these claims, you bring it under federal law. But if you're saying a state law has been violated, you bring the class action under that state law with whoever is covered by that statute. What's wrong with that?
There were many states that prior to CAFA applied the doctrine that if a tort emanated from their state, that they were willing to apply their state law to a nationwide class. Since class actions under CAFA no longer can be brought in those state courts, that doctrine could very easily be applied by the federal courts.
But the vast majority of states have rejected that. I mean, the Washington State
but
Supreme
it's not
Court
as if
rejected
it's not
it
as if,
today,
okay,
and let me tell you why.
But it's not such a fantastic notion that you could find a state law that would apply nationwide.
Sure, it's a fantastic notion.
Why is it a fantastic notion that if somebody commits a fraud in New Jersey and then exports it to the rest of the country, the New Jersey law should apply?
I think states are each rightly concerned. I mean, I saw it in New York when that issue came before the New York Court of Appeals. The judges were sitting there and hearing the prospect that if you're a New York citizen and you bought a product from a company in Arkansas, that the rights of the consumers in the state of New York might be determined under Arkansas law, which is not as good as New York law, which is what the Washington Supreme Court said today.
Right,
We're going to
But now under CAFA, it's not going to be determined under the law of any state because it's not going to get anywhere.
You bring a law. Elizabeth is right. These are being brought all the time. And the New York,
but not succeeding.
New York citizens,
being filed doesn't mean anything. It only matters if the class gets certified.
I gave you statistics earlier.
Class doesn't need to be certified to settle.
Right. But then we start complaining about the weak results. You're weakening the plaintiff's lawyer ability to get certified the class, and then we're criticizing the weaker settlement because these cases are impossible to litigate.
How many cases, Ted, settled before? How many non-securities cases, let alone securities cases, settled before certification?
Well, Joe's about to make a lot of money on the Mattel case, and it's not like he uncovered a wrong there. Mattel admitted that they had lead in their toys. And he's getting a full refund for everybody and lead medical testing, right? And did you get certified in that? How much?
We didn't get certified. What we did was survive Mattel's primary argument was that the voluntary recall that they went through immunized them from further relief, from us getting further relief. And we argued that and briefed it repeatedly and won that issue, and the judge, a Republican-appointed judge, ruled that no, the voluntary recall did not immunize them, and then we settled for full refunds and additional things like lead testing, and we exempted all personal injury claims from the settlement, so people are free to go forward if there are such claims. But are we getting a huge windfall? It's basically a lodestar fee after a lot of work in the case if the fee is approved. But It is a settlement after serious litigation on a motion to dismiss, which I think is comparable to what you often find in securities litigation. You don't always go through class certification. You frequently do. But I think the point that's being missed here, the issue that was being presented, I think, and being raised by Arthur, is do you have a choice of laws question? Should that be federal versus state in terms of how you're going to choose the law to apply? And you can build all sorts of protections, as many states do. If consumers are left worse off by the choice that results, then no, you don't apply it. That's one rule that comes out of many states. So the question of what the choice of law rule is could easily be a federal question if class actions are to be federalized, as John convinced Congress to do. Then that issue could easily be federalized and say, this is the rule. And what that rule results in is sometimes it'll apply one state and sometimes it won't. It depends on what the rules are going to be.
It could be federal common law, something this court would never accept, and
Right.
we know that.
And it's not that it's impossible to conduct a sufficient choice of law analysis under existing rules, doctrines, and statutes to certify a nationwide class. It can be done. It's very difficult. It's a very expensive proposition, and it takes about a 60-page opinion from a district court to go through all the levels of choice of law analysis, as the District of New Jersey did in the Mercedes-Benz TeleAid litigation, which certified a nationwide class after a multi-level choice of law analysis that looked at the choice of law doctrines and the substantive law and the comparative interests of 10 different states. And that decision was so well considered and rendered that when it went up on 23F appeal, as was inevitable, the Third Circuit let it stand after the same circuit court had issued the hydrogen peroxide decision. It's doable, but I can tell you, as one of the firms involved in that litigation, that it took a year's worth of briefing. It took a very energized, intellectual, committed, engaged judge who was willing to lay bare his analysis to appellate scrutiny in a case that was hotly contested. That calls for a lot of judicial energy, resources, courage. That's a lot harder than it needs to be.
We should have slipshod standards for
No.
certification of class actions. So lawyers have to do work, judges have to do work, and cases that are involving
No.
tens of millions, if not billions of dollars, are being done in a very careful way.
Absolutely
What's wrong with that?
Not. Absolutely not. But you don't have to maximize every procedural burden and every expense to have a fair, clear standard. Part of the problem is the way choice of law has developed in this country. That's not Congress's fault. That's not the judge's fault. That's not the lawyer's fault. But it can be fixed or clarified or made less expensive and less confusing. Courts can do it jurisprudentially. Congress can do it legislatively. And in an era where we're all trying to reduce the cost and delay of litigation because we don't want it to be a burden on those who have been injured or damaged, we don't want it to be a burden on the companies that have to defend themselves, and we don't want it to be a drag on our economy, it just seems to be a matter of common sense that we have a multiple law world in the U.S., and a law has to be chosen in every case where people from different states have at each other, and it ought to be as doable in a class action context as it is in any other A against B litigation, because the result always matters or there wouldn't be a conflict. The stakes are high. They're never higher than in business-to-business patent litigation or business-to-business litigation where millions or billions of dollars are at stake. And there's a choice of law problem, and the court chooses the law, and it has consequences. The courts have not, most courts have not been willing or able to choose the law in class actions, although they're under no more difficult constitutional constraints.
And what's wrong with the notion, you referred to it before, of remitting these class actions when they're in the diversity context to statewide class actions?
Well, that's really the if they hand you lemons, make lemonade solution, and lawyers are doing that. And if you've got a few big states, Florida, Texas, California, and New York, that may be doable in a given case, and we're doing it. But, you know, the rule about, you know, when they hand you lemons, make lemonade, works for a while, but justice doesn't live on lemonade alone. In the long term, you know, you need a balanced diet.
Block that metaphor.
Now, it sounds, although you're not saying it, the obvious consequence of allowing statewide classes and picking up the low-hanging fruit, New York, California, et cetera, means that Wyoming, Idaho, Alaska, and Montana get nothing.
That's happening a lot, and it's not fair to those who live there. And I don't think it's what anyone would have in mind in terms of coming up with a procedural regime that would allow people across the country, however populous their state, to have an equal shot at redress of their grievances when on the facts, they've all been treated the same way. The products that go to Wyoming and Montana, for the most part, aren't any different than the ones that go to California.
Can you identify a single consumer fraud settlement that was not a nationwide settlement and that somehow excluded Wyoming or Idaho?
Yeah, recently there have been a number of regional settlements for that very reason. Most settlements tend to be nationwide, but one of the things that prevents those settlements from being optimal is that a discount factor that's going into those settlements to a greater or lesser degree is the fact, and the defendants bring this up every time, that for trial purposes they couldn't be certified on a nationwide basis. So everybody suffers in the class in part because the challenges to litigating a class action on a nationwide basis have gotten higher. That's part of the dynamics that go into settlements. If nationwide class actions were easier, you wouldn't have that discount factor, at least. And as far as the federal statutes, I know about civil RICO. I was waiting for John to give us the list of the other federal statutes that we can bring the class actions under.
Bring a long list. They're brought every day in the financial services arena and so on. There are many statutes that were ignored in that arena that have been rediscovered. I think that from a policy standpoint, this all sounds great. We can rearrange the choice of law world in order to facilitate nationwide class actions. But I think the reason why the vast, vast majority of state Supreme Courts have refused to go down the road of saying we will apply our laws externally is because of the question, all right, whose law are you going to apply? Professor, under your proposal, it was before Congress. I think it was, if I remember it correctly, it was focused on, you know, where was the core of activity. You'd basically go to the corporate headquarters and look at that.
That was one of them.
Yeah, that's the one that went to the Senate floor. But think about, do you really want motor vehicle law, product liability law, defined by the state of Michigan, which is what you'd end up with there if you did that, where the state legislature presumably is going to say, we're worried about the industries and we're going to define it the way we want to for the nation. Now, maybe that's not the way it would work, but I'm just saying the decision's got to be made. I mean, if you just want to say, we'll have federal law for everything, well, that's an interesting proposition. But the fact that you have these cases in federal court, I don't think dictates that you have to have federal law governing all of them. I think that really goes way too far. And to say that we need to redefine legal principles and take away the state's right to define what consumer rights should be in their states to facilitate nationwide class actions is a fairly breathtaking proposition.
Breathtaking?
Yeah.
Federalization of all class actions, that's breathtaking.
No.
A federal common law choice of law rule for interstate disputes is a sniffle compared to that.
Didn't federalize class actions. It's diversity jurisdiction.
Class actions were already federalized. Yeah. The problem was that they were being federalized in Madison County.
Wouldn't like their forum.
Well, we should also talk about why that happened and why many of these settlements are nationwide settlements. It's because the defense attorneys on this panel represent clients who demand nationwide settlements. That's why they get settled that way. And in the securities arena, there's something similar going on. They spend all their time fighting worldwide class certification because securities today are traded all over the world. But when those cases are ready to be settled, they demand worldwide certification. So I think, you know, putting all of this on the plaintiffs' lawyers who are litigating these cases is just incredibly unfair and misleading. And I think to then criticize them because their cases are settled on a nationwide basis, when basically a gun is held to their head saying we cannot and will not settle unless you give us a nationwide class, is something that the audience needs to appreciate.
Well, the one thing we haven't talked about, which is probably the most important thing, is very few of these cases are ever tried. It's all about the class certification decision, which is why I think the changes in the rules to permitting appeals on a discretionary basis are a good thing, because no one ever goes to trial in these cases, particularly in the securities arena, because of the amount of money that's at stake, and it becomes sort of a roulette game, and so that's why people settle. So what's happened in the law, which everyone is getting so in such a tizzy about, is we're having a little bit more process and procedure and protection before a case gets certified, because the certification decision is the big enchilada. Once you get past that, there's a settlement at the end of the road because no one wants to go to trial because they're afraid to run the risk of a runaway jury, which is a real risk.
Well, I've tried
factual
two.
decisions being made.
I've tried two, one for defendants and one for plaintiffs.
Okay, two. How many have you settled? Hundreds, right?
I've settled a lot, but the fact
Hundreds,
is,
I'm sure.
people do go to trial.
Okay, and most commercial litigation in the United States settles, not just class actions, but
You're right.
One of the largest class actions in American history is now before a jury in the Southern District of New York.
The Vivendi case.
Yes.
And what's interesting about the Vivendi case is that we're using the United States courts, we're now litigating about people who bought stock in outside the United States, non-U.S. citizens, in a non-U.S. company. And we're basically allowing our courts to turn into the world court for these securities class actions. Now, in that case, they have a claim that some statements emanated from the United States, but there's a provision that's being debated in Congress that would allow someone who's a stockholder in a European company who bought stock on a European exchange when the European company issued all of its disclosures outside the United States, and somehow to try to get it in the United States just because that European company happens to list in the United States. That can't be good for our country.
Okay. I want to go back to the point that Bob made about, and what Arthur referred to as the searching inquiry. And, you know, Bob's point about the fact that it's a good thing now that we've got more of a record being developed on class certification. You know, we got to keep in mind the fact that what we now have on class certification is very much akin to a final determination on the merits in place of the jury trial that you say does not usually occur in class actions. The difference is that these factual determinations, which judges have never been permitted to make previously in the class certification context, are now being made by the judge. They're not being made by the fact finder. So you've got ultimate determinations of fact being made at the class certification stage, not by the fact finder. And that's a significant change in procedure.
Although sometimes it becomes purgatory. You look at the Duke v. Walmart case, for example. As I understand it, merits discovery was suspended 5 years ago, pending subsequent serial appellate review.
Yeah, well, that's the other point. Then you've got judges who will limit discovery and say, oh, you can only have discovery on class issues. But then you get to the class certification hearing, and the class certification hearing involves the plaintiffs being required to bring forward a record to support the elements of their claim when their discovery has been limited to class certification issues.
Or prove causation, as in the Fifth Circuit.
Well, the Fifth Circuit has a standard for proving causation that simply can't be met by any living lawyer. So.
Yes, the best thing that can be said about the Fifth Circuit is maybe it doesn't exist. Maybe it's a figment of our imagination.
Huh.
Let's go to the audience. Questions, comments, observations, bricks. Yes, go ahead. Microphone.
I think that searching I think that, my name is Lori Feldman. I think that certain people on the panel are drinking their own Kool-Aid. To the extent that those people believe that class actions are a bad thing. I will just tell you one point that was emphasized sometime today, that I was recently in a court last week in a case that will remain nameless, where the parties had reached a settlement that the judge thought was fair. But the barrier, at least one barrier to that settlement, is the affidavit that the defendant's expert put in on class certification. And the judge held that expert affidavit up and said, what do I do about this? I bet, defense lawyers, you're sorry you put this in. So, yes, everything deserves a balance. I agree with Sal. I agree with many others, Joe, that, of course there are going to be situations that aren't going to be fair, but the courts are watching. The judges are there. The class actions do serve a purpose, and without us, you'd be out of a job.
Yes, anyone else? Anyone else? Yes, we got one back there.
Is Jane Greengold Stevens, and I've been doing class actions in the context of public interest law for the last 20 or 25 years. And I just want to say that I find it somewhat upsetting that in the context of a day about access to justice by the American Constitution Society, that 90% of the conversation about class actions is all about securities transactions. And I'm worried, too, about spillover, and that the effect of these things is going to have a very bad impact on our ability to represent classes of people. In most cases, we're suing the government, trying to get benefits that have been provided by the law but are not being provided in practice. And we need the class action mechanism to get retroactive benefits when we win, and it's very important to us. And I think it's important to remember that this mechanism is used not only in the securities area.
To make that point, we often work with nonprofits, and the first thing they say to us is, we have no money and very little staffing. Can you help us?
Anyone else? Yes, right here.
My name is Howard Fisher, and I find myself somewhat amused by one of the comments that the panelists made about, well, look at the other parts of the world, they don't use this class mechanism. Leaving aside the fact that some kind of representative action is actually becoming more popular in England and in Europe, isn't it a bit odd for people on the right or Republicans to say the Supreme Court should never ever look at decisions of foreign courts or practices of foreign nations? We have to be very careful to preserve our American values and our American jurisprudence. But when it comes to limiting access to the courts, it's, look at what China does. I mean, sure, they execute people who happen to disagree with the government, but they have a couple of good things to say on class actions. And this reminds me, I was at an international bar conference a couple of years ago in Sweden, and this was before the collapse, and I was having drinks, 3 or 4 or 7 or 8, with a couple of lawyers from England and from Iceland. And they were mocking me and a couple of lawyers with me who were from the United States, because they said, your securities regulation system is so incredibly intense and obtrusive. Luckily, we live in England and Iceland, where our regulators know not to tamper with a goose that lays the golden egg. Does any of this resonate at all?
Anyone else?
Don't get to defend
else?
myself.
Anyone want to answer that?
Yeah, I'd be happy to. I mean, I think the point is a different one, which is that in countries which are viewed to have more communitarian society, national health insurance, they don't have as much litigation as we have in this country. My point, which I've been trying to make, maybe not as well as I could be, was that you need some balance in the system. And if somebody can just come up with a complaint, say, I represent all the people in the world who bought this product, and my client was injured by it, and then go and get it certified without much review, and then walk up to the defendant and say, I'm going to go to trial in Madison, Wisconsin against you for billions of dollars, what do you think that company is going to do? It's going to settle. And the costs of that settlement are not just borne by the evil CEO and the evil CFO, which is something people lose sight of. It's borne by the employees, the community, and the larger society. The question is, what is the appropriate balance? And in Europe, they have much smaller, to the extent they have group actions. It's maybe 100 people, 200 people, not the whole world or the whole country.
But if I could just take your indulgence on that response, if the answer to the problem of excessive class actions is that we need some form of socialized medical care, why isn't that point being made?
I assume.
Well, why isn't that point being made by those who oppose class actions? I think if we took a poll here, and I'm willing to take it now.
Howard, I beg your indulgence. Howard and I are old friends, and we're in law school together, so I can cut him off. For those of you who arrived after the beginning, I'm Caroline Fredrickson, the Executive Director of the American Constitution Society. I want to thank all of you for coming, and I want to thank our fabulous panel and Professor Arthur Miller. Very, very stimulating discussion.